Good morning, Umesh sir.
I'm sharing my presentation, ma'am.
Already change the schedule some little bit. Yeah. Thank you. Continue. Okay.
Good morning, everyone. I welcome you all to the last session of series on perspective on IBC. Today we have with us Prakul Thadi sir as speaker. Sir will be taking session on the topic role of related parties under IBC. Let me briefly introduce Prakul sir. Sir is partner at Prakul and Kuvarpreet LLP company secretaries. He is also IP CS lawyer and cost accountant with prior experience of over and above 3 years in Necto Pharma Limited in his litigation and secretarial team. He has undergone 9 months practical training with Ernst& Young assisting successful implementation of resolution plan of large steel manufacturer based in Maharashtra and played critical role in compliance management, litigation, plant visits and operations oversight of goods-based auto component manufacturer undergoing CIRP. He was also trained under the guidance of judicial and technical members at NCLT Chennai. Since past years, he is actively working on IBC mandates as RP liquidator and as advisor to IPs in handling their assignments. His areas also include implementation of resolution plans where P and K offers is blend of knowledge on both the corporate and insolvency laws. Now I request Prakul sir to start the session.
Thank you, ma'am. Hope my voice is audible, ma'am. Anjali ma'am, can you please confirm that I am audible? Hello.
Yeah, you are audible.
Anybody? Yeah. Okay. Thank you, sir. Good morning, everyone. Thank you for giving me the session. Special thanks to ICSF for giving me this opportunity to present this session on role of related parties under IBC. So my focus will be more on a few parameters, which I will just take you through. Allow me to present my screen. Just a second. Okay. So as you can see on my screen, what we will try to discuss today in this session will be first related party. I'll not each and every aspect of it, but yeah, I will touch base on certain key aspects, the definition of party. And then we will talk about the role of related parties at the time of initiation meetings or access to confidential information, participation as a PR. So as we start, let us first quickly understand and run related part.
Voice is breaking.
Sorry, my internet connection. Yeah. So yes. So as I was saying, in case of a corporate debtor, the director, partner, or the relatives are deemed to be related parties. Right? Yeah. So this particular clause is something which is different from the Companies Act 2013, because this clause is not there in the definition of related parties under the Companies Act, which says any person who is associated with the corporate debtor on account of participation in policy making process of the corporate debtor. Now see, this is, just imagine as an RP, for us to conclude that a person is participating in the policy making process of the corporate debtor is an extremely challenging thing. But that is something which can make, even if that the person does not have any shares in the company, right? Even if that person is distantly not related because of any other clause, but if you know, as a matter of fact, or by some method of documentation, if you can prove that that person was responsible for making the policies of this company, then you can account for and make that person as a related party. Or second, having more than two directors in common between the corporate debtor and such person. Now, just imagine if there is any other company with common directors of more than two. So, which means three or more, right? More than two. If you have just two common directors, it will again not be a related party. If it is more than two common directors between two companies, irrespective of whether those two companies have any other association, if they have two common directors between them, then it would amount to a related party. Now, see, this is not present in Companies Act, but this is present in this particular definition of related party under IBC. Now, just imagine, let's say there is a listed entity, right, which is undergoing CARP. And in the listed entity, let's say there are three directors, independent directors. Okay, because here there is no distinction, it just says directors. Three independent directors are there. Let's say those three independent directors are actually independent, having professional knowledge, and let's say they are stalwarts in their own field of subject. So similarly, some other listed entity has also got these three independent directors on their board. Okay. Now, these two listed companies do not have any common relationship between them. They're completely distinct. They're operating on their own, maybe in the same business line. Now, if this one of the listed entities is undergoing CIRP, then by definition, because of this definition, both these companies A and B will be considered as related parties only because they have got more than two common directors between them. Now, this is one interesting element which was never, I have not seen this definition of a related party under the Companies Act or under even India's or for the fact unraveled here. So
Not at all audible.
Sir, voice is brisky, not at all audible.
Not audible at all.
Maybe his internet connection is not clear, I think so.
sir, I'm just changing my internet connection. Sorry, one second. While I'm presenting my screen, it is having some problem.
Sir, please repeat the second slide onwards, please.
Sure, sir. We'll do that, sir.
Yeah.
Yeah. Sorry. So, with respect to, as I was saying, yeah, this, I was only trying to focus on this part of the definition of related party, because that is something which is different from any other definition of related party under the Companies Act or any other legislations. So now, I mean, because I'm not sure what extent you all were able to hear me, so I'll just quickly repeat. One, if a person is, if you have evidence to prove that a person is participating in the policy making processes of the company, then irrespective of whether that person has any shares in the company, irrespective of whether that person has any directorship or, I mean, of course, directorship, they're a related party, irrespective of whether that person does not have any commercial relationship with the company, you can still make that person a related party as long as you have evidence to prove that they are key or they are participating in the policy making process of the company. Now, second, where you have more than two common directors between the company, corporate debtor and the other company. Over here, I was giving you an example of, let's say, two listed entities having three independent directors in common without any business relationship. They don't have any transactions, no business relationship, nothing. But still, because of this particular definition, since they have more than two directors in common, by this definition, both the entities will be termed as related parties. So therefore, whenever any PRA is participating in the process, or whenever any, that there are certain directors on the board of your company, better to go and check what are the other companies in which these directors are also directors, so that you can ascertain. Of course, you need not do it like a detailed research, but still only on a simple footing, if you can try to do this, you will get a fair idea of who are all the related parties of the company, particularly from the point of view of having more than two common directors between the corporate debtor and the other entity. Next is interchange of managerial personnel between the corporate debtor and the other person. So it is a usual practice in group entities that where one of the company secretaries of this company will now be moved to another company to become a company secretary there because of the minimum requirement, etc. Similarly, one of the directors of the one company will also be appointed as one director of the other company in the course of time. Even though they're again without any common holdings, maybe employees themselves hold shares between both the companies. But when they see this kind of a pattern, which is very normal when you see a group entity kind of a structure, then in that case also you can make both the entities as related parties, even though they don't fit under any other definition provided above. Next, provision of essential technical information to or from the corporate debtor. Now, essential technical information is not defined under the code, right? So, which means it is completely subjective, or rather, you can rely it on the general meaning which you can associate with that. Now, this will basically depend upon what kind of business the company is into and how important this technical information is for the particular company. So if that essential technical information is being availed from any other entity, or if our entity, our corporate debtor is providing that essential technical information to any other company, because of which the business of the respective entities are being taken care of, then both the entities will be deemed to be related parties to each other under the definition of IBC, right? So this particular clause M is a new clause inserted under the IBC, which is different from what you see of a related party definition under LODR or companies. Now, apart from this, few more important things for us to know in terms of parameters is this. One is related party, control of the corporate debtor. Now, let's say you're not in day-to-day operations of the company, but for some fact you own more than 20% shares in that particular company. Then by virtue of owning 20% of voting rights in the corporate debtor, you will be deemed to be a related party, right? And next, any person in whom the corporate debtor controls more than 20% of voting rights. Now, on one side, where a person is holding 20% of voting rights in the corporate debtor, that person will be tagged as a related party. On the other side, where we are holding more than 20%, that is, the corporate debtor is holding more than 20% of voting rights in any other person, be it a LLP, be it a company or anything, or any other body corporate, then both this company as well as the other party will be deemed to be a related party on their own. So will be deemed to be related parties, right? So this way, this definition provides for who is a related party to a corporate debtor. And as I said at the beginning, a director or partner or a relative thereof is also a related party. Now, who is a relative? All of that is being defined under this section 5, subsection 24, clause A, right? So section 5, subsection 24, clause A is basically providing for a status of a related party in relation to an individual, right? So whenever you are talking about related party of an individual, then this definition will come into picture. So particularly when we are assessing the status of a PRA who is an individual, this will help us. Because if there is an individual, see, whenever we are doing the status between corporate debtor and the some other person, then we will refer to section 5, subsection 24, because it's a definition of related party in relation to a corporate debtor. Now, in relation to an individual, this will be the definition. So, which is obviously a relative, and then of course these are all standard things. So I'm not dwelling much into this. Unless anybody wants me to, I'll be more than happy to take it. But ideally, these are all standard. But one important thing which is added here is with respect to being a trustee. So a trustee of a trust in which the beneficiary is including the individuals, etc., then the trustee will be deemed to be a related party of that particular individual for all practical reasons, right? Then going by the definition, of course, these are all the standard definition in terms of a relative, which is all the four sides of your relationships. Basically the spouse, all the members of the HUF, father, mother, son, daughter, their children, all of that will come, and your siblings will all come under the definition of relatives. And wherever we are talking about son, daughter, sister, brother, even their spouses will also be included in the definition of relative. So this is what is clear in terms of definition of relative. But only one interesting aspect which can be a matter of interpretation, obviously, is that if you see the definition of section 5, subsection 24A, related party wherein it talks about in relation to an individual, right? Only under that section we have an explanation wherein it says for the purposes of this clause. So basically for the purposes of section 5 subsection 24a, they define who is a relative. But we also find a similar notion in or similar terminology used in section 5 subsection 24, while there is no explanation given in this particular subsection. Positively, we should align with the same explanation provided under section 5 subsection 24a, which is the closest to section 5 subsection 24. Nevertheless, maybe in some cases this can be a matter of dispute, but otherwise this is the same definition which we will assign to both section 5 subsection 24 as well as section 5 subsection 24a. So this is with respect to the definition of related party. Now let us pause for a moment, right? Okay, now let us say we know who are all the related parties. Okay, now how will it affect in terms of the process, right? That is what is extremely important. Now, if somebody is a related party, will it have an impact for running the process of CIRP? And as a resolution professional, what all safeguards we need to have in place to ensure that we are not contravening the provisions of the code? Now, that is what is extremely important for me as an insolvency professional, right? And that's what I look at as the role of a related party. So for that, let us run through the next thing, which is initiation of CIRP. Now, for initiation of CIRP, what is the provision we look into? We look into three provisions: section 7, section 9, and section 10. Correct? These are the only sections which deal with initiation of CIRP by a initiation of CIRP. Basically, these are provided under section 7, section 9, and section 10. So let us just read these three. I mean, very quickly understand these sections, which I'm sure many of us already are aware of. So initiation of CIRP by financial creditor. Okay. Now, in this entire section, there is no exclusion of a related party from initiating a section 7 petition against the corporate debtor. So what does this mean? If there is a related party who has given a financial debt to the corporate debtor, and such debt is not repaid by the corporate debtor, then such related party financial creditor may also initiate section 7 petition under IBC, right? So there is no bar on a financial creditor who is a related party from initiating CIRP before the NCLT. None of these sections, section 7, nowhere does it prohibit a related party from initiating a CIRP. Now, let me give you an interesting case study which we did, where we have advised a particular client. So, in one of the matters, there is a director, I mean, a mother of a director. Okay, so the company has two directors, A and B. One of the director A's mother is C. Okay, now A's mother had given a guarantee to the loan availed by the company. So both A and B have also been personal guarantors. A's mother is also a personal guarantor. A's mother's property has also been provided as a security for the loan taken by the company. Now all of this is clear. Now the next step what happened? The next step what happened was A's mother had repaid the loan because there was a recall of loan and invocation of guarantee. They have invoked the guarantee against these two guarantors, and the guarantor A, which is the A's mother C, had sold her property, right, and repaid the amount of loan, whatever was settled with the bank, and the bank had given a full and final settlement against the company. So the debt is clear. Then came the concept of subrogation of rights. So that's where we advise our client that, okay, you better have a subrogation of right. So A's mother had, by way of subrogation of rights, had become the financial creditor of the corporate debtor, right? Because earlier it was the loan given by one Karnataka bank. Now, when she had repaid the loan as a guarantor, then she will step into the shoes of a creditor. And as per the Indian Contract Act, all the rights, all the terms and conditions which apply for that particular creditor shall equally, without any exceptions, apply even for the guarantor who has entered into the shoes of the creditor by way of right of subrogation. Thereby, this particular guarantor who has repaid the entire loan has now become a financial creditor. And then subsequently, she, in her capacity as a financial creditor, filed an application under Section 7 before the NCLT. Now, is this prohibited? The answer is no. The reason being, Section 7 nowhere prohibits a related party from initiating a CIRP. Similarly, if we look into Section 9, Section 9 is initiation of CIRP by an operational creditor. Even under Section 9, there is absolutely no clause. There is a requirement of a procedural aspect like sending a demand notice or an invoice demanding payment, and then subsequently giving 10 days time, then making a filing an application before the NCLT. That procedure is there, but nevertheless, for that particular procedure, there is no prohibition of a related party from initiating an application under Section 9 of IBC, right? So therefore, a related party may also initiate an application under Section 9 as an operational creditor. So if a related party had supplied certain goods or provided certain services to the company and the amount remains unpaid, then even such a related party will be within her or his or its rights to file an application under Section 9. Then comes Section 10. Now see, Section 10 is absolutely clear. The one who files is a related party only, because Section 10 is an application for initiation of CIRP by the corporate debtor itself. Now, corporate debtor itself is nothing but, by way of a special resolution, one of the directors will be authorized to file this application. So technically, a related party is only filing an application. So for Section 10, it's an application by the related party itself initiating a CIRP against itself. So Section 10, there is no need of a discussion as such on that. Right. So now as far as the initiation is concerned, now we are clear that there is absolutely no problem in terms of initiation of in terms of initiating a CIRP by a related party. Then comes the discussion on, okay, boss, the related party initiated it, but what will you do? Will you allow him to participate in the meeting? Can they be participating in the meeting? Right. So that is a relevant question to answer. So before that, let us now understand with respect to meeting of COCs, who all can be or who all are mandatorily to be invited to be present in the meeting of COC, right? So for which is nothing but to whom all should we as insolvency professionals, should we as resolution professionals send the notice inviting the meeting of the COC. So that is number one, to all the members of the COC. So these members of the COC can be, ideally will be all financial creditors. If there are no financial creditors, then operational creditors of top 18 in number, etc., right? So firstly, to the members, we will send the notice. Then second, we send the notice to the suspended board, members of the suspended board. So the board is suspended. So to the members of the suspended board, we will send a notice. Now, tell me this, whether the members of the suspended board are related parties or not. Answer is yes, they are related parties. That is the first clause. All directors or the relatives are related party. So the members of the suspended board of directors or the corporate debtor still participate in the meetings of the committee without any voting rights. They will not have any voting rights, but they can still participate as well, and we have to mandatorily issue a notice for them to be part of the meeting. Right. So this is an important point which we need to note. So no, obviously this has become a clear practice. There is no question of doubt at all. But from an academic point of view, this is an interesting thing that a related party is mandatorily to be attending the meeting only when they are suspended board of directors. They are members of the suspended board of directors of the company. So they have to be mandatorily invited to notice. Now there is a small discussion I would like to make here, but let me just finish the next point and come. Now, operational creditors or their representatives, if the amount of their aggregate dues is not less than 10% of the debt. Okay. Now, for point A and point C, see, point A is you being a member of the COC. Okay. Now, point C is an OC or a representative where the entire aggregate debt of OCs is more than 10% of the total debt. So now let's say the total debt of the company is 100 crores and the OCs together are having more like 12 crores. So they're having more than 10%. So a representation if you see the next point, even though the notice goes to everybody, the participation is given in subsection 4, which says the directors, partners, and one representative of OCs as referred to in subsection 3. No, one representation relative of OC. So there is a kind of a process we have to run to see to it that one OC is being representing the entire class of OCs to be part of the meeting to discuss, to participate in the COC meeting, right? May attend the meetings but shall not have any right to vote in such meetings. So they have a right to attend the meetings but not to vote in such meetings. Okay. Now it only says attend. Now, what is the interpretation of attend is left to us. Like either we can say attend means you just have to be there and be present to see what's happening, or they can be allowed to participate to an extent where they can provide their inputs, but they cannot be allowed to vote in any of these meetings. That point is clear. Second, they also made it very clear that in an event they are absent, it will not invalidate the proceedings of the meeting. Thereby, it is absolutely clear they are not even computed for the question of quorum. So they are never part of the quorum. If they are there, okay. If they are not there, it's completely fine. You can continue with the agenda of the meeting. That is one thing. Now, coming back to what I would like to discuss is with respect to the members of the suspended board of directors or partners of the corporate debtor, as the case may be, they can be present in the meeting, right? Okay. Now, if this suspended board is part of the meeting,
Indian voice is disturbing, sir.
they know what is happening, any matters that has become a matter subsequently. So, is there any way we can contentious things initially when IBC was obviously at its nascent stage? There were few matters where when the resolution plan discussions were happening, or the copy of resolution plans were not being circulated to few or to all the suspended directors on the ground that these are related parties and they can create some noise. And they went to the NCLT, NCLAT, and subsequent to the Supreme Court, where the Supreme Court made it extremely clear that as a participant in the meeting of the committee of creditors, they should be allowed to be given access to information, including copies of the resolution plan, right? So we have that order in Ultratech Cement, where it was it was made clear that the directors will also be given access. I mean, Ultratech Cement is the PR there, but yeah, where they have been made clear that they can, they are being given access. They can be given access to the copies of the resolution plan. Okay. So, anyways, we will get to that. Now let's take one other situation. The situation being, okay, there is a member of the COC. For being a member of the COC, that is, let's say there is a financial creditor who is a related party, right? Now, a director who is not a creditor, who is just a director and still sitting in the meetings, that is one part of the story. But let's say you are a related party holding more than 20% shares in the company, and you are also a member of, I mean, you're also a financial creditor. Can you participate in the meetings of the COs? For that, we need to see, one second. Yeah, 21. Yes. Section 21, which talks about committee of creditors. Now, this is what we need to refer to whenever we are looking at participation of a related party in a company, in a COC. Now, if you see here, subsection 2 says the committee of creditors shall comprise all financial creditors of the corporate debtor, provided that a financial creditor or authorized representative of a creditor referred to in subsection 6 or 6A or subsection 5 of section 24. Now, these are nothing but an authorized representative or a financial creditor who is like we have just seen that part with respect to being a member of the COC, etc. If it is a related party of the corporate debtor, so where a financial creditor or an AR who is being appointed is a related party of the corporate debtor, they shall not have any right of representation, participation, or voting in a meeting of the COC. Now, see, the terminology used is representation, participation, or voting. Now, the terminology used in section 24 is attendance. Basically, they may attend, right? Now, here that is for directors. But whereas for financial creditors who are related parties, it is extremely clear they can neither represent nor participate nor vote in a meeting of the COC. That is, they don't have any voting rights. In the complete total financial debts of members of the COC, these financial creditors will not have any voting rights. They will not be invited to the meetings, and they will not be allowed to participate in the meetings. Therefore, these related
But they are part of
financial
COC.
creditors are.
Sir, they are part of
Sorry?
COC.
No, sir. That's what I'm trying to say. They are not part of the
This
COC.
question is
They are not part of the COC.
They are part of COC.
They are
They does
not part
not
of
have
the
the
COC,
right
sir.
to represent, participate, or voting in the meeting, but they are part of COC because in one of the case, I was the related party. I was the related party means the related party was also into CIRP.
Okay.
So CIRP that my company was a related party. I had filed a claim as a related party, and the claim was admitted, and I was in the COC, and the other RP filed IA for claiming the CIRP cost as a COC member because you are a COC member. So as a related party, though you cannot vote in the meeting, you cannot participate in the meeting, but you will have to bear the CIRP cost. What is your say on this?
Sir, firstly, my say is ideally, I don't know why they're allowing you to be in the part of COC. Probably, if other members have allowed in my view, you cannot be part of the committee as well. So, what is the committee? The committee of creditors is nothing but okay. Even if you say for the theoretically you are part of the COC, you cannot be part of the discussions of the members of the COC. This is number one. Number two, you will not have any voting rights as such. So, the committee itself comprises of financial creditors having voting rights. Now, if you don't have a voting right, even if you claim to be part of the committee, you cannot ideally be called a committee of member of the committee as well, because there is absolutely no representation which is being provided to you. What is meant of representation, sir? You
No, sir.
representing
See, this is not my take. This is the take of the other RP who said that this section 21 subsection 2 is saying the committee of creditors shall comprise all financial creditor of the corporate debtor.
Correct.
Then provided that you do not have the right to represent, participate, or vote. So you are not representing, you are not allowed to participate, you are not allowed to vote, but you are part of COC. And since you are part of COC, you will have to pay the CIRP cost.
Yeah, I know. I'll come to CIRP cost, sir, separately. So first and foremost, as regards the claiming you to be part of the COC, it only is trying to say that you are a financial creditor. It's not actually to say that you are a part of COC, but rather the fact is you are a financial creditor. That is clear. Now, in a situation of contribution to CIRP cost, that's where you need to go away beyond the committee. You need to see, generally, sir, where will we get as an RPs? Where will we get the fund from? Either we get the fund from the operations of the CD, or we get interim finance, or we take contribution from the members. No, absolutely right there. You trying to, I mean, from the RP's point of view, also there is some validation where if you are a
even RP can't send any notice to this.
Yes, absolutely.
Can't send.
No, sir. RP cannot send. RP's point of view is for contribution to the CIRP cost, he wants all financial creditors to contribute, including related parties.
Perfectly.
So that is something which is not trying to give you a right of being a COC, but again, just on a discussion of point that you are a financial creditor, not member of COC, but a financial creditor. As a financial creditor, he definitely can come and say, boss, I need a financial creditor to contribute to the CARP cost, because ultimately it's an interim finance. It will be treated as interim finance, given higher record. And even though you are a related party, whatever CARP cost comes in, first it will be repaid to all the interim finance providers, including a related party FC. So no, sir, the point is there a right for the RP to claim that amount from you? Obviously, that's why he has filed an IA with the NCLT. Now, can the NCLT give a direction to financial creditor who is a related party to contribute? The answer
So
is yes.
this
NCLT can
matter was
definitely do it.
tested. This matter was
Ah.
tested. This is a recent case. This
Mm.
matter was tested by NCLT, but NCLT itself, Mumbai bench, they were confused on this point. But I got this dismissed on another ground, their claim, because I am into CIRP, and since I am into CIRP as a related party, so you cannot claim anything. I have a moratorium. So on that point, it was dismissed. But this particular point was, means the NCLT itself was confused that what should we do, because they are financial creditor, they are related party, they are COC as per the definition subsection 2. They are COC member, but they do not have the right to vote or participate. So being a COC member, are they liable to pay the CIRP cost or not? See, is still open.
Agreed, sir. Totally agreed. That's what I'm trying to say. If you see this sub-regulation 34.5 under CIRP regulations, which talks about fee paid to IRP and RP, and by fee, they also mean all other costs, not just the fee. That fee will also, if you see fee under 33 and 34 are nothing but the costs. So for that, it says that the fee under this regulation may be paid from the funds available with the CD, contributed by the applicant, that is the original applicant who has filed the CARP petition, or members of the committee, and or raised by way of interim finance and shall be included in insolvency. Now, this is only which says may be paid. Now, that means as a RP, I can approach first the CD, the funds of the CD. I can actually ask the applicant only to contribute, or I can even request the members of the committee. Now, here my interpretation is, you are not a member of the committee, sir. You might be a financial creditor. The reason being simple. I don't send, as one of the other RPs, Ravi sir, is also highlighting. I don't send a notice. I don't invite you for any meetings. I will not let you participate in any meetings. I will not give any right to vote. Thereby, you are not a member of the committee. But
so
you are
the
a financial
other RP's view was that he
understood,
is
sir.
a member of committee. He is a
I
member of
understood that.
committee.
Correct. I mean,
As per
I'm not
section 2.
again.
So this is an interesting point, and this is
True.
yet to be tested,
Very
whether
true.
he is a member of the committee or not.
Correct. Very true, sir.
I
Because
was raising the points what you are saying, that I am not getting any notice of the meeting. I am not participating in the meeting. I am not representing. I am not allowed to represent. Then how can the CIRP cost be claimed from me? I do not have a voting right also. And this section is saying maybe. All these points have been raised by me. But still the court was, the NCLT was confused that though all these points are there, but still, as per the definition, you are the member of the committee.
Understood, sir. No, even that argument has some weightage, because if you see this provision, it's trying to say it will comprise of all members. It will not say that all members are members also. If you see that way, it doesn't actually say so, but still okay. It comprises all FCs, but those FCs who are related parties, they cannot represent, participate, or vote. So if that's the interpretation we make, that zero voting right has been given to this particular financial creditor member. So then, okay, that's one point. You're absolutely right, for the courts to give a clarity whether they are member of COC or not. But yeah, both the sides, we have enough arguments to make, I believe, sir. But other side, I don't know. I am not, at least personally, I am also not of that view. As you rightly said, I also don't feel that is a right interpretation to make. But from the financial creditors availing an interim finance, I can still approach NCLT as a matter of direction to give all the financial creditors to contribute. That particular element is still there. But I think in your situation, because you are a company with CIRP on your own, so there is no point taking money from you. So I think luckily, at least that interpretation is taken by the NCLT, and you are excluded from contributing to the CIRP cost. But yes, sir, I agree. This is an interesting point. Whether all the related party FCs are members of the COC, or are they considered completely away from the COC, is something which I think you're right. It has to be clarified by an order. But now currently we can have our own opinions. At least while running the processes, I think all RPs are extremely careful in terms of not ensuring they are not being made part of any of the discussions.
But
So that is one
Yes, yes.
point.
That we all are doing, but this point when raised, I was
Yeah,
amazed.
even I
Yes,
am surprised. Yeah. Yes,
but
sir.
as per the procedure, code procedure, the IBC code procedure, it is barred. They can't.
Yes. Yes, yes.
right, sir.
Yeah. Yes, sir. So now we'll just further extend this discussion to see what are the exceptions for this particular proviso. So it is nothing but non-applicability. Now, when does this not apply? That is again an interesting thing for us to know, is that it will not apply where a financial creditor is regulated. So a regulated financial creditor will not have this embargo. Now, who is a regulated financial creditor? The one who is regulated by a financial sector regulator. And okay, this is point number one. That is, a financial sector regulator is defined above, which will include RBI also, SEBI also, which will include, these two basically, RBI and SEBI. And even under SEBI, there are certain things which we will quickly see. But first and foremost is that should have been regulated, and it has become a related party solely on account of conversion or substitution of debt or instruments or completion of such transactions prior to the ICD. So, which means it should not have subscribed to the equity by an allotment. That is, it should not have infused money into the company as an equity shareholder. Rather, it should have converted its debt into equity or substituted its debt with instruments convertible into equity. Only then they can claim exception. So, which means as RPs, we have to go one step ahead. Okay, we saw that there is a financial creditor. Let's say there is a bank, or let's say there's an ARC which is holding shares in the company of 21%, let us say. Now, when we see that they are holding 21%, we know they are related parties. But when we come to the proviso, we know they are regulated by RBI. So that itself does not give them the immunity of not being a related party of the company. Or rather, they're still related, but that will not give them immunity from saying that they can still participate as a financial creditor in the COC. No. We should also see we should go back and understand how did the 21% equity come to that particular ARC. What is the evolution of that equity? Had there been any chance that they have infused the money into the company and become a shareholder, then they cannot be given that exception, even though if they are regulated by the financial sector regulator. So only situation where they can be exempted from being a related party of the corporate debtor is only when that particular equity is by virtue of conversion of their debt into equity or substitution of their debt with equity or convertible instruments. So this is extremely important from the point of view of giving exceptions to them from being a from being a COC member or rather financial creditor having right to represent, right to participate and vote in a meeting of the COC. So let us quickly see who are these financial sector regulators. The financial sector under any law for the time being in force to regulate services or transactions or any other body coming at a later stage will also give an RBI, SEBI, IRDA, Pension Fund Regulatory Authority, and other regulatory authorities as may be notified by this government. But I think this should be more than enough. Now, this particular definition and this particular interpretation we are doing only for the sake of understanding whether such financial creditor is part of the COC or not. Correct? So this is something which we need to be extremely careful about in terms of giving a voting right to the members who are part of the COC. Now, this is one side of the story. Now, let us understand. So now we have seen firstly the definition, then we have followed on initiation, whether they can initiate, definitely yes. Then we have seen on participation in the COC meetings, we have seen yes, they can still participate. I'm sorry, if they can participate if they are suspended board of directors. but they cannot participate if they are related parties and not suspended board of directors, and they cannot participate if they are merely by virtue of them being related parties, they will not be allowed to participate, represent, or vote in COC meetings. Now that is made extremely clear. But there is one interesting element which will come, particularly from the point of view of related parties. That is, see, under section 24(3), we know that all the members of the suspended directors should be invited to the meetings. Now, what if the suspended board of director is also a financial creditor? Okay. So a suspended board of director who is also a financial creditor who has submitted his claim and is claiming as a financial creditor, can such suspended board of director be allowed to participate in the meeting, allowed to represent himself in the meeting? The answer is yes, but in his capacity as a director. So that's the beauty of corporate law as such. In under the corporate law, every person has got different every let's say, for example, a company has got a director, has got a shareholder, has got an employee, has got a supplier, has got a creditor, right? So from the point of view of the company, even though a single person, let's say an individual A, can be a director, can be a shareholder, can be an employee also as a whole-time director, can also be supplying goods to the company, can also be purchasing goods from the company, right? And can also be funding the company. So from the point of view of the company, the person A has played multiple roles, and each such role is individually being recognized by the company. Right? If you are a director and a shareholder, as a director, you need to give some approvals. As a shareholder, I will take other approvals. Now, as a creditor, I will take approvals when I am doing a scheme of merger. So technically, being a director or and an FC both, you will be treated individually. That is, as a director, can you be participating in the COC? Yes, I will allow in the COC. But as a financial creditor, you cannot raise any matters, any topics in the COC. You cannot claim any right of representation. You cannot claim any right of voting as a creditor, right? So therefore, your rights will be only limited to you being a director of the company. Now, is it well understood by everybody in in terms of directors? Do they limit their role like that? Obviously, no. They try to overboard every single time, but still, the idea is we have directors on the board so that they guide the COC in terms of certain areas where we might not have prior knowledge of what's happening in the company. But as directors, since they are involved in day-to-day operations, they can better guide us is what is the holistic view of allowing them being part of the meetings of the COC. Right? But obviously we know what all they do being part of the COC. That is completely different from the very objective of the code. But still, the very objective is that they should give us a guidance by being part of the meeting. But what do? They say that, okay, sir, our lawyers will attend. Now, sir, I also invite views from other RPs. In my particular view, I don't think a board of directors should be allowed to authorize any other person on his behalf to be part of the meeting. A simple reason, sir, is that let us forget the fact that the company is under CIRP. If it is a board of directors meeting, can the board authorize his advocate to attend on his behalf?
No.
The answer is absolutely no. Companies Act does not allow a director to substitute himself with any other representative other than an alternative director. So a director, if he is not able to attend the meeting, if he wants somebody else, there is no concept of proxy for directors. If the director wants somebody else to attend the meeting on his behalf, on her behalf, then they have to provide for an alternative director. That is a concept in itself under the Companies Act, where the alternative director should also hold a valid DIN, and they should be appointed as an alternative director on the board by filing a TAR 12, and their role will and they can be appointed only when the director is not present in India for more than 180 days or something. Only then they can be allowed to be part of the meeting. Now, there is a complete concept under the Companies Act, and none of the directors will take this advantage of giving allowing an advocate or somebody to present in the COCs. But unfortunately, under the IBC, it is still like a double-edged interpretation, wherein the suspended members of the suspended board of directors at times they send us emails saying that my advocate representative will come on for the meeting, and they will not turn up. The advocate will turn up and sit in the meeting. No, my simple question is, what is the role of an advocate to sit in the meeting? I mean, no offense to advocates, but the point is they are not the directors of the company. The whole objective of having a board of director to be in the COC is so that they can help us with the information about the company. Now, the objective is not to monitor and see what advantage that fellow can take or what advantage he cannot take. So there are instances where I disallowed directors to authorize any of their advocates to come without their presence. So initially I used to disallow that also, but because other members did not have any objection, we allowed the director along with the advocate, but not the. Within the absence of director, there is no way, in my view, sir, maybe if there are differing views, director cannot substitute his role with an advocate or his counsel. I don't think that is a right practice in my personal view. So that is with respect to participation of members or suspended board of directors. Even if they are a financial creditor, they can still participate as participate in the COC as a director, but not as a related party FC. So this is another point I thought I'll quickly bring up. Yeah. Move forward. Next is with respect to access to information. Now, if we look at creation of IM, it very clearly says the resolution professional shall provide to the applicants access to all information, right? So under section 29(2), the concept is purely providing an IM to the PRA. Okay. Whereas under the regulations, it very clearly says the RP shall submit the IM in electronic form to each member of the committee. Okay, sir. So now, again, if we go back to our earlier kind of a healthy debate, where we were saying whether a non-related party is a member of COC or not, then Manoj
Sir, view is not, the voice is not clear, sir. Again,
this regulation clearly IM to each member of the committee, circulate only to those who are having voting rights, and not asking any question, just trying to say that as per this regulation 36, the RP shall submit IM to each member of the committee. So I was just on a lighter note asking whether you have received IM in that particular case or not, because they are claiming you as a member of the COC. In such case, they should also circulate the IM. No, that's what I'm trying to say. But
no.
anyways, the idea is to just highlight the fact. Yeah, sir.
No, I have not received.
Yeah. Correct. That's what, sir. It's a selective interpretation. But anyways, so the idea is to say that RP will be submitting the IM to each member of the COC. Now, does the member include a related party FC will be the next question. So can the RP make IM available to a related party FC? The answer is no, in my view. Now, can I consider a financial creditor related party as a member of the COC to circulate the IM? I don't think so. That should be the situation. So we should not circulate IM to related parties, and that will also include our directors. Just because directors are allowed to participate in the meeting, this particular regulation to directors. So therefore, we cannot. Therefore, we cannot provide the IM to submit the IM to the other suspended board of directors of the company. This should be only for each of the member of the committee. And for that, we will also take a confidentiality undertaking from the members that they do not disclose this part. So that is where it is very clear that such member maintains confidentiality.
But sir, IM is to be given to the directors also, no, sir?
Sir, ideally,
IM
as
needs
per
to
this
be given to the directors.
No, I mean, I don't know. So at least as per this regulation, it is not required.
The regulation is silent. It is not even saying no to the directors. And
Sir,
there are court cases where it has been said that I am to be given to the directors, and even I am sending the I am to the directors with a question mark that if you have something to add to this information, please help us. I am sharing even the
of
draft
course,
I am
of
after
course.
taking the confidentiality undertaking.
No, sir. Absolutely, sir. I don't see there anything wrong in that also, because we take all that information from directors only. So ultimately, the directors only give all the information in the IM. So I don't see any mistake in that. But I'm just reading what is there in the regulation. So regulation is very clear. It simply says I have to submit it. My responsibility is to submit it to each member of the committee. Now, if I am giving it to a director by taking a confidentiality, is it prohibited? No. Definitely, regulation is not prohibiting it. At the same time, regulation is not keeping it as a responsibility on me to submit the IM to the director. That's what I'm trying to highlight. So I totally agree the fact that the entire IM is prepared only based on the information which I received from the directors of the company. Whatever we see here, all of it as ideally would be given from the directors of the company only. But having said that, the regulations mandate is each member of the committee. So this compliance, I need to ensure I am taking silent on whether you can give, not give. It is completely silent. So that depends on how we are interpreting. But as a responsibility of an RP, it is to circulate to every member of the COC is my responsibility. Yeah, sorry, sir. Go ahead, sir.
RP, it is not the RP's duty to circulate it to the directors. Why? Because we obtain the information from him only.
Yeah,
Hmm.
correct. That's my view also. Yes. So,
But sir,
and
my
again,
view is clear that in so many cases we get information from other sources also, other than the director. And when we prepare information memorandum, it should be sent for comment to the director, because it helps, because afterwards directors file so many IAs that this is not included, this asset was left out, this is done, that is done. So we get
agreed.
safeguard from the directors that it has been, the information memorandum has been shared with you, but you have never raised these points at that time. So my understanding is that we, as a good practice, we should share it with the directors and ask their comment on that
100%.
if there is
Fair point, sir.
anything which is missed out.
Agreed, sir. I think that way some level of litigation can be avoided at least, where they cannot claim back and say that I have given all the information, but the RP has not included it. Karke. Okay. Fair point, sir. Point well taken. This is one, and then okay, this is one of the confidential information which we are sharing, but again, sharing with the board of directors is different from sharing with the see, as all the RPs also agree, with related parties access, there is no way as an RP we will circulate this IM. Aspect of circulating a resolution plan. So now resolution plans are also definitely confidential, more confidential than the information memorandum. Of course, information memorandum is confidential from the company's point.
Sir, voice, there is no voice, I think. No voice. Sir, not audible. Hello. Sir, no voice.
sorry. Yeah. Therefore, you cannot prohibit a financial creditor from being a PRA. At the same time, you cannot uh, say that I will not be sharing the other resolution plans with you because that fellow is already in the position of being a financial creditor. So, in a nutshell, where a financial creditor is one of the PRAs, then a financial creditor will have that advantage of receiving the resolution plans because the financial creditor shall vote on such resolution plans. That's where in one case we handled it where we have taken a legal opinion and then we did something like the one who is representing the financial creditor as a PRA, we kept it different from the one who is being present in the committee as a member, and we took Chinese wall distinction and declarations, confidentiality agreements, etc., from them. Only, of course, from the point of view of the documentation. Now, had the code prohibited them from being a PRA, that would have been a different situation. But since they allow them to be part of a COC, therefore, we had to come up with something to ensure that at least on the level of documentation, they are ensuring that they are not given additional advantage by being a member of the COC. So, just to quickly repeat, where a director is also a PRA under Section 240H, where they are allowed, where they are given, sorry, under Section 240, where they are given, sorry. Yeah. So 240A, where they are given exemption from this, and they are, let's say, a promoter of the company who's also director is participating as a PRA. In such a situation, we may have to end up giving. We will have to ensure that he is not being made available with the other resolution plans. Okay. So this is my view on this. Any contrary views from any other members of the committee based on their experiences, I'll be more than happy to listen because it will also help us in understanding what level of practices we have to keep in place for PRAs who are, for related parties who are also PRAs, particularly where the directors are also prospective resolution applicants. Uh, any experiences from the RPs who are present in the meeting? It will be good to hear. Otherwise, we can continue with the last part of my presentation. Okay. Now
Sir,
coming to
how
the
can
last.
we stop giving the copy of the resolution plan to the director?
Yeah, correct, sir. I want to hear from you, sir. What do you think should be a right thing to do if we are giving him?
My understanding is that we should be transparent. If you want to reduce the future litigation, if you want no disturbance or minimum disturbance from the promoter, you should provide the copy. Let him raise the points, whatever points he wants to raise, and let that be placed before COC, and let the COC decide. No? And if based on those resolution plan he wants to increase his bid or something, whatever he wants to do, let him do.
What if other PRs litigate, sir? Saying
How
that
can they litigate? How can they litigate?
no,
See,
they will do
he
the
is
same
getting
thing.
he is getting this resolution plan based on his status as a suspended director, part of the COC.
Uh,
And how can they litigate that the copy should not be provided to him?
no, they
There
will
is
say the
no
same thing.
reason.
He is getting the advantage, no? As a
So,
PRA, I want a
even if one
level.
financial creditor who is not
Correct.
a related party,
Correct.
if he is submitting the plan, he is
Ah,
getting access to all the resolution plan. So similar is the
yes.
situation in that case also.
Agreed. Totally agreed, sir. That's what is the best we can do there. So we should not do anything. We should simply give the plans to everyone, and whatever happens, we will just go with the flow. Correct? That's what we are
Yes,
trying
yes,
to say.
yes. This is my understanding that we should
Ah,
provide the copies of the plan to the people who are eligible,
hmm,
including the directors. Let them
hmm,
make their comment. Let the COC decide. See, ultimately, it is COC who has to decide with 66%.
ah,
So it should be an informed decision.
hmm.
So
So instead
being
of
an
avoid
instead of holding anything from
Hmm.
anyone, let the
Ah.
competition flow.
Ah.
Let the competition be there.
Hmm.
And at the end, everyone is having the same time and date to submit the final plan.
Correct.
So I think my understanding is that we should not stop it.
Okay, sir. Fair point. Point taken, sir. Any other views from others? Okay. But one point I agree on that is that, sir, both if a financial creditor can be given that same level of importance by giving the copy of plan, why not a suspended board of director is definitely a valid discussion point, because he is also having a right to receive the resolution plan. Same footing, financial creditor is also having a right to receive a resolution plan. Now, only difference between them is that a suspended director has no right to vote on a resolution plan, whereas a financial creditor has to vote on a plan. Therefore, keeping them on an equal footing is, I mean, on this particular point alone, there is a distinction why there is a reason for circulating a resolution plan to a financial creditor versus why there is not a requirement to submit to a director. This can be one point of discussion or debate. But other point of discussion is that, as you rightly said, okay, let it be there, and ultimately one final date will be given for submitting the final plan. So whosoever can come with the best plan can come at that particular point in time and give whatever the amount you want. So the director will not reduce his plan amount basis what others have given. Rather, the only situation can be the director might increase his plan amount basis what others have given. But
So that is good for the COC. No?
correct. That is good for the COC. Therefore, even other PRA cannot go and say, sir, see, I would have given a lesser amount because of director, I had to come with a higher amount. Even he cannot say that.
Yes.
NCLT will
Yes,
not
yes,
entertain.
yes.
Correct. But
Yes,
only
yes.
situation where something can go wrong is when all the PRAs can rig each other, saying, suppose there are two PRAs, one is a director, that fellow knows what the other fellow has bid. Now he'll go there to him and say, why are you bidding so much? Let us bid very low in the second round and let us take the company, which
Sir,
anyway.
rigging otherwise also you cannot stop, sir.
Correct.
Even
No, I'm
directors
just
are
trying
get
to
in touch with
keep up,
others. Rigging
yeah.
you cannot stop.
Correct. Totally agree. So yes, sir. So very interesting points these are, particularly from the point of view of directors. Things will become fishy if they are too interested in the company. If they are not interested in the company, then there is we can run the process smoothly. There is no problem. But if they know, if they want the company back and they will do anything possible to disturb the flow of the RP, which we see in majority of our cases. And I think there, one thing I totally you is that, sir, our approach should be to won't be able to close this. Lesser the litigation we can keep, the better the chances of revival of the company. So I totally agree with you on that, sir. So finally,
And sir,
one
my
point,
understanding is
sir.
that the directors are either eligible or not eligible. If they are eligible,
Correct.
they should be given all the details. If they are not
Correct.
eligible, they are not eligible. That's all.
Correct. I totally agree, sir. If at all regulators want us to do something different, they have to bring it clearly in, as part of the regulations. They cannot
Yeah, right.
expect the
Uh,
RP to interpret
we should
anything.
not
If
be
they
we
want
should
us
not be
not to
over
go,
cautious. We should not
correct.
impose something from our own mind.
Agreed, sir. And if the IBBA wants us not to do something, better that has to be provided in the regulation that boss don't share it with the director or share it with the director. Something like that has to be clearly provided as a process.
Yeah, right, sir. Right.
Otherwise, yeah, you are very right. If there is a, then what should stop me from giving to the last element of our session, which is with respect to the effect of section 32A. So section 32A, though there is no heading to 32A, ideally, if you see any other section, it comes with some of the other headings. But unfortunately, for section 32A, there is no heading. But any which ways, it is to be read as an immunity to a PRA. So that 32A provides immunity to, sorry, not to the PRA, but the corporate debtor which is resolved under CIRP from any pending prosecution or from initiating any prosecution for an offense which is done before the insolvency commencement date or for an prosecution which is instituted during CIRP, the liability of a corporate debtor for an offence committed prior to commencement of CIRP shall cease. And the corporate debtor shall not ban has been approved by the. Now, similarly, Section 32 CIRP, it shall stand discharged from the date of approval of the plan, subject to requirements of the subsection having fulfilled, which is nothing but two things. One, I have to continue giving cooperation, that is fine. But most important thing is, if the resolution plan results in the change in the management or control of the corporate debtor to a person who was not a promoter or in the management or control of the CD or a related party of such person, okay, or a related party of such person. Now, essentially what it is trying to say is the management or control of the corporate debtor should go to a non-related party. Only then the Section 32A relief or the immunity can be enjoyed, right? And next, a person with regard to whom the investigation has on the basis of material in his possession reason to believe that he had abetted or conspired for the commission and has submitted or filed a opinion to the relevant authority, so and so, he should not be the one. So this should not go to the person who is actually subject to the investigation. So that point is clear. So technically, if you want immunity under Section 32A, you should not be a related party, right? That point is clear here. Now, my question is, if the company is acquired by a PRA, who is the promoter of the company? There is no change in management because of Section 240 Section 240A. That person is eligible to be submit a plan because he is exempt under 29AC and 29AH, or otherwise, let's say that the company is not an NPA, it has not been declared an NPA yet. He immediately initiated the process. Therefore, by default, he is eligible as a promoter. I mean, nobody stops a promoter or related party from PRA. It prohibits if you meet any of the PRA. So that way, if the promoter exists,
Sir, voice is not clear.
herself had taken over the company. Okay, sir. I will repeat, sir. Sir, what I was trying to say is Section 32A clarifies that if the resolution plan results in change in management to a non-related entity, only then it is very clear under Section 32A. My only question is, what if the successful resolution applicant is the existing promoter of the company? Can he enjoy a clean slate or even from criminal prosecution, or will he still be continuing to defend the company in all the prosecutions which are against the company? That is my simple question, because the Section 32A precondition itself is change in management or control to a person who was not a promoter in the company. So if it is to a person who is a promoter himself, then what is the question? So then ideally, as per direct interpretation of Section 32A is, it is prohibited because it's very clear. If there is no change in management, you cannot claim immunity under Section 32A. So therefore, even if you are a promoter of a company eligible under 29A, submitted a plan, gave the highest settlement amount, became a successful resolution applicant, you can still be haunted for offences committed prior to commencement of the CIRP. That's the statement I am making. What are any of the participants have any contrary, or are you also on the same lines? I'll be more than happy to hear you out. Okay, no problem. So yes, so this
Sir,
is one.
my view on this is
Yes,
what
sir,
you
yes,
are
sir.
saying is 100% right.
Hmm.
The only thing is that
Hmm.
he will get a clean slate from the
Claims.
like Income Tax Act. If
Correct.
there
All
is
the
a
liabilities
claim,
he will get. Yeah, yeah.
liability he will get it. But as far as offences are concerned,
Hmm.
criminal offences, I think on that he will not get any clean slate.
Yes, sir. So if you see this point, sir, point, yeah, this point, where it says that whosoever was in charge able to be prosecuted. So therefore, technically, individual level, on his individual level basis, even if the company is getting resolved and acquired by another PRA, this fellow is still subject to investigation, because ideally it's a criminal offense. So a crime is something which cannot be immuned against the individual. So against the company, it can be immune, because a company is nothing but it's like an artificial person, which is a collection of association of people who are actually directing a company. So against the company, they are giving relief, but against the individual, there is anyways no relief. But if the PRA himself is the promoter, then even against the company, there is no relief. So therefore, the company is also will be continuing to fight all this litigation with respect to all the criminal offences, which may also include the check bounce matters, or even other. I mean, check bounce matters again is a very entirely different discussion to make. But yeah, other criminal investigations like ED, CBI, etc. against the company will keep on continuing. So I think that is one area where probably promoters also come with very unique solutions. But yeah, so this is on the level of law. This is what it is with respect to claiming criminal immunity under Section 32A of the Code. This is an interesting section, which is still that the power of this is still under review by the Supreme Court in where they are evaluating the conflict between PMLA and IBC. As and when that order comes out, probably we will have much more jurisprudence in terms of how Section 32A has to be interpreted, because currently there are several orders based on Section 32A, not disputed. NCLTs have given, various NCLTs, NCLAT have given. But the one fundamental question is ED attachment being released is something which is still a point of view, which I mean, still a subject matter of litigation even today, any which ways. So this is from my end with respect
So
to
in
the
that
role
case,
of. Yes, yes,
in
yes.
that case, it is High Court has already given the order, Bombay High
Sir.
Court, for against PMLA, but it is pending in Supreme Court. And Supreme Court order may come anytime, means it
Yeah.
is for hearing actually, pending for hearing. And ED is taking time in that
How
matter.
32 is that? Yeah. Yes, 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 agreed, sir. But once we get that order, we will have a much better participation of PRS also, because many companies where ED attachments are there, PRS are also hesitant in few cases to take that chance. We have
So
seen
that is my
recently
matter
also the
only.
Supreme Court order, which is currently under review. Acha, acha, acha. Okay, sir.
Let's see, sir.
Okay. Yeah, yeah. Okay, sir. So that's all from my side. I am open for any further questions or discussions from any of. Thanks to Manojji and Ravi sir for sharing your line of thought process, because that made it, for me at least, very interactive and interesting to continue the session. I wanted to keep only highlight on certain key factors like this, which are conflicting, which has conflicting interpretations. So I hope the session went interesting. Any feedback is welcome, and any questions or anything to discuss, I'll be more than happy to take up the questions. Otherwise, we can conclude the session. Okay. So thank you everybody for participating in the session, and thank you so much once again, Manoj sir, for making things extremely interesting for me. And thank you, Raviji, also for sharing your valuable thoughts during the presentation. I now request Anjali ji to take it up and conclude. Yeah. Yes, sir, Manoj sir.
Thank you, sir.
Thank you, sir.
It was really very precise and perfectly articulated by you.
Thank you, sir. Thank you, sir. Yeah. Anjali ji, you can take it up, ma'am.
Thank you very much, sir, for giving such a valuable session, and thank you participants for joining the session. So
Yeah,
please
thank you so much.
share the PPT of the session.
Sure, ma'am. Sure. Thank you, ma'am. Okay. Thank you, everyone.